Good morning,
This
everyone.
meeting is being recorded.
All right, so let's go ahead and we'll start with item number 1, roll call. Dr. Kawaguchi.
Sorry, I was on mute here.
The questions get tougher as we go.
Mr. Moridomi.
Here.
Mark has a little exclamation symbol next to his name. I don't know if he's having internet issues. Mark, can you hear us?
I can hear you. Can you hear me?
Yes. Okay, yes. So, right, you're here. And then Dr. Turetsky.
I'm here.
And Dr. Wong here. So we have quorum and we're all present. Let's go ahead and go on to item number 2, which is public comment for items not on the agenda. Moderator, if you could open up the Q&A, please.
All right, this is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on agenda items not on the agenda, or for items not on the agenda, please click on that Q&A icon at the bottom right-hand corner of your WebEx screen. Currently sharing instructions on the screen for your reference, and in the Ask field, typically in the lower right-hand corner of your WebEx screen, please type, "I would like to make a public comment," and send to all panelists. All right, and it looks like at this time there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
All right, the Q&A panel is now closed.
Okay, let's go on to item number 3, which is discussion and action. Discussion and action on minutes from September 18th, 2020. Does anyone have any comments regarding those minutes? If there are no comments, could I get a motion to pass the minutes from September 18th, 2020?
It's Dave. I'll motion to accept the minutes from September 18th, 2020.
And
Glenn will second.
perfect. Moderator, if you could open up the Q&A for our comments, please.
All right, this is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this motion, please click that icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. And it looks like at this time there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
All right, Q&A panel is now closed.
All right, we're going to go ahead and take a vote. Dr. Turetsky?
Aye.
Mr. Moridomi?
I will defer voting until I see what the rest of the vote is. If you need my vote, I can vote in favor of it. Otherwise, I prefer to abstain.
Okay. Dr. Kawaguchi?
Aye.
And Dr. Wong? Aye. So I have 3 ayes and 1 abstain.
Yeah, I'll abstain. Yes.
Motion passes. And let's go on to item number 4, which is discussion on changes to chapters 5.4, 5.45, and 5.5 of the BCC Optician statutes. Does anyone have any comments regarding possible changes?
I have a few comments. Do you want me to dive in or?
Yes, please.
Okay. So first off to staff, thank you for the work that you've been doing on this. Obviously, there were quite a few changes that we needed to make just because it hadn't been touched in so many years. So I appreciate those changes. So as far as my comments go, I guess I can just go in order. Do you want me to do that, Lillian?
Yeah, I think that would be the best.
Okay, so on page 12, under 2541.2, G, so section G on that page 12. So we're trying to make it clear about what G means. And so I could see that in the past it was a little confusing. And I honestly had to read it 5 times, even with our change, to start to understand what we meant about when an optician or a CLD, for example, can charge fees for service. I just wonder if there's an easier way to word it. So I think, in optometry, we say that fees are due when services are rendered. It's kind of a simple statement. I don't know if it's specific enough to have in regulation, but G seems like over wordy to get to the point that an optician can charge even if something wasn't prescribed yet. Isn't that what it's saying?
Dr. Koguchi, which section are you talking about again? Just so I make sure I'm looking at the right one.
It is 2541.2, section G.
So this is language that mirrors the federal statute. And so it is a bit wordy, but in going through the contact lens rule, this is exact language that comes from that same rule.
If nobody else was confused by it, I'm fine. I had to read it multiple times to understand what it meant.
Let me catch that again. You just gave the citation again, and I missed a digit. You said 25. Give me the statute again, if you could.
2541.2.
41. No wonder. Okay. 41.2.
Paragraph G.
Okay, so this is on page 12 of the packet.
Correct.
I see. Okay. Thanks. Let me take a quick look here.
May I make or ask a question? Hello?
Absolutely, as far as I'm concerned, if that's who you're asking.
Okay, yeah, on this, and I didn't even notice this till Glenn just brought this up. What happens if an optometrist or a physician and surgeon writes a prescription, writes an eyeglass prescription, and then puts down, okay, for contact lenses. And they say, go to the optician, and the optician will fit you with contact lenses. So the optician does a fitting and provides contact lenses for somebody. Can that optician write a prescription for the contact lenses that they have fit and dispensed? Or who writes the prescription for that?
So I'm not sure that would be the best practice. And that's interesting if that is common practice. But
I'm just wondering because I mean, I know I know many ophthalmologists will just put down something like okay for contact lenses because they're not going to fit a contact lens, and they'll say, go get it filled. So you go to an optician, the optician will fit you with whatever. Who writes that prescription? If the patient wants a copy of or the patient has to get a copy of their contact lens prescription.
So anecdotally, my example would be the ophthalmologist in my area. Even if they have a CLD, they actually write the prescription. So the prescription is written by the ophthalmologist.
Yeah, because an optician cannot write a prescription, right? No.
No.
I wish we had Madhu here right now because I'd like to know what Kaiser does. Because I know the contact lens fittings, at least they used to be done by the contact lens folks over in the optical department, not by the optometrist.
But would they go? I wonder if they go back to the optometrist for a contact lens check at the end.
Maybe, probably. I don't know the procedures.
So Natalia, there is a section in the contact lens dispenser statute that does talk about once a contact lens is fitted, they need to be referred back to the optometrist or the ophthalmologist. Originally, we weren't particularly sure what case would have been needed for that statute, but after hearing you guys talk about this, it makes a little more sense now.
then that would explain it. And the optometrist or the ophthalmologist is the one who would write the final prescription based on what the optician hit the person with.
Correct. That's what it
Okay,
sounds.
cool. Cool.
Very observant, Dr. Turetsky.
I wouldn't have seen it if Glenn didn't bring up the point. So kudos, Glenn.
So this is Mark. Just some general comment going to the core of what Glenn said about drafting. And I leave the professional stuff to you guys. In my heart of hearts, I agree with Glenn. If it's incomprehensible, then we should try to fix it. However, if the people out there in the professional world understand what this language means because of it mirroring the federal statute or the federal rules in this area, if everyone out there knows what this means based on the interpretation of the federal statute, then if there's no confusion out in the public, then we probably shouldn't change it. Because changes mean that we had a desire to make our intent different from the federal intent. So it's a tricky thing. I mean, the folks at the federal level aren't very good drafters also, so we don't want to repeat a mistake. That said, we should be careful as to how we change it if there's no misunderstanding out there.
Yeah, I'm fine. I'm fine if we leave it. I just was confused by it, and I fear that registrants would be confused as well. And I'm always looking to try to reduce confusion if possible. But I don't have a strong opinion that we have to change it if it's mirroring federal law. So that's fine with me.
This is board counsel. If you find that you end up in a position, I think what you guys have just said is a good starting point because of this idea that it's mirroring something that's already out there, and there might be enough in current practice that it's, there's not necessarily an issue or a problem. But then in practice, if board staff starts to see that, oh, hey, this isn't being interpreted right, or we're starting to see we have enforcement issues on it or something like that, that might be where it's a helpful area or an appropriate time to start looking at regulatory language, because that's your chance as a board to have more control and more specificity from there. And it allows the stuff that the legislature has control over, the stuff that you won't have a chance to, you won't have the maneuverability down the line to always update or change as much in theory. Usually the idea is your own regs is the place where you have more of that flexibility and chance to adjust and chance to specify. And so that's so it's kind of a two-part thing. One is if it's not broke, don't fix it. So if this ends up working just fine. And then part two is if staff finds there is a problem, that's where you've got that room to make clarifications in your regulatory language.
Rebecca, is there any other course if someone calls us up and says, I have no understanding, I can't figure out what this means. Can you explain it to me in layperson's language? Is our staff handcuffed and say, I'm sorry, you're out of luck, you have to carry your own attorney? Or is there a way through fact sheets or other kinds of informal publications that we can explain things like this if it becomes an issue, short of going through the regulatory process? Sure,
exactly. Yeah, there's probably a bit of a mix of the two. And of course, I want to zero in on what you just said, which of course, if there's an issue, right? So, but it is kind of a mix because you can theoretically also stave off issues with things like newsletters and just sort of general informational things if that's in place to help notify people. So the reason I said it was a kind of a mix is because yes, you have that side where you can just be educational on a broad level. You also, on the other side, yes, the board doesn't want to be in a position of interpreting the law or essentially providing legal advice for the public. So that's why I said it's a mix. But yeah, there's some room there where the board could do a bit of educating if it thought it was helpful or necessary, of course.
So unless somebody else wants to change it, I'm fine with leaving it as is for now. Okay, so the next comment that I have, or actually it's questions, is on page 15. So we've been consistently trying to refine paragraph B1, which is around fines. And I have a couple questions on this one. So should there be a wording change here for any person and or entity? Or maybe this change is not in the appropriate spot, because I think from the DOC, their intent is to ensure compliance with RDOs. I don't think we've established a concern with SLDs and CLDs as far as consumer risk or harm, and a need for a change in this section. So could it be that it's supposed to be in section 2564.80 only? I just am raising those questions around location for it. Again, what I'm kind of trying to get at is, if we look at specificity of fines, I'm okay with us having a range, but at the same time, I want to be mindful that I don't think that there's been established risk, large risk to consumer with SLDs and CLDs. And we're trying to protect consumers also by allowing them access to care through these individuals that are registered with us. And if we create a new statute that is so scary, I'm concerned that the amount of SLD, CLDs that we have is going to continue to be a challenge. So that's the question I have. Is this in the correct place? Do we need to have a separation of fines? Can we have a separation of fines for SLD, CLD versus RDO? So those are the questions that I have.
This is always a glance across the top, see if anyone else is unmuting before me. Don't want to step on anyone as they're talking. So, okay, so you guys have seen the comments here. There's obviously this sort of tension between, I feel like there's a few different things happening. There's the tension between this idea of whether you've got a fine for a person versus for a corporation. I'm also looking at it as a tension between what you want in statute versus what you want in regulation, because of the flexibility that it can afford you. And then I think your question is sort of saying, if that, on that issue of the corporation, are we capturing it in the right place? Because of course, this statute technically already says any person. And then help me understand the part of your question where you were saying, you were talking about the impact to SLDs, CLDs, and RDOs. You were sort of saying that, does the fine amount impact them? Or, yeah, help me understand your question there.
This is kind of a reach, to be honest, but one of the things I personally am looking at as well is I want to make sure that we have people in our industry that want to be an SLD or CLD. And in general, my fear is overregulation could risk that.
I see what you're saying, I think. Yeah. Yeah. And that, so, okay, so I guess that presupposes this idea maybe that someone entering the field takes a look at this statute and goes, whoa, $35,000 if I ever make a mistake. I can't, take that risk. Is that kind of that kind of idea? Yeah. My impression, and this is where staff probably has more of a well-rounded look at this, but my impression would be that it's going to perhaps matter more what's happening in practice, what gets clarified in regulation, what kind of note, it's not, I don't think it's all that common that people have that approach. I think what's more common is word of mouth, an understanding of, general, often I would think it's the schooling that's informing them what kind of landscape they're looking at. Again, I think what's more pertinent to us in this moment is going to be, are we applying the right things to the right people? And I'm using the term more loosely because we have this corporation aspect. If that, as in that comment, if the $35,000 isn't even meant for individuals, then let's maybe clarify or remove or relocate it. I don't know. If your staff thinks that having that $35,000 is an important thing to get in there so that they have some, the capacity to do that for corporations, and it really should be there, then let's find the most appropriate place for it. If it can be left, I guess what I'm getting at is, let's clarify on the enforcement side, I think, what's going to be the most effective, and then we change the language from there. I don't know that it's that common for somebody choosing a profession to say, let me go check Business and Professions Code section 2545 and see what I think. I don't know that that's going to be as much of a concern there. I guess what I'm trying to say is, I can't know that, but if we have the statutes accurately reflecting what your staff needs to actually do, that's where we want to be.
Okay, so I was thinking about worst case scenario just now with an SLD. So let's say an SLD is practicing optometry or medicine, ophthalmology, and a person loses their vision or loses their eye, or even their life. Therefore, a person, so a single person, we may want to subject a higher level fine to that person. And so the highest level fine that we're currently defining, $35,000, may absolutely be appropriate.
Here's the thing.
Yeah.
Pardon me. Here's the thing. I think at that stage, you're looking more at accusations, an eventual revocation or some other sort of penalty. This is where, of course, staff can correct me in terms of what their priorities are. But I think those are the scenarios where we're not actually trying to fine people. Because again, your role for consumer protection, your focus is never about punishment, right? Your focus is about discipline or penalties that protect that cause consumer protection, right? So, or help instill it. So I think that's the kind, when you have those egregious, basically violations of minimum standards or violations of the Practice Act, I don't foresee that being the kind of situation where you're worried about slapping a fine on somebody. That's more, okay, we're going through the disciplinary process to determine, does this person need to be on probation, or do we need to just get their license out of there, that kind of thing.
Okay.
Which is why
So my attached question to that then is, if we keep it as it is for the most part, will we address the comment by one of our staff members about who it's addressing? Is it possible from a legal statement to say any person and or entity? That way it's clear that we're encompassing both SLD, CLD, as well as RDO.
I think that could work.
I think we could really just be, our RDOs are required to be incorporated. So we could, I think that, any person or corporation who violates, I think that would clarify that this is a span that is not just personal liability, but corporate liability. And then particular to what's required within Business and Profession Code, what's required within Corporation Code, that our RDOs are an S or C corporation type.
Rebecca, is person defined someplace to include individuals, corporations, S corporations, partnerships, all that? So do we need that additional language?
We can cross-check within your Practice Act because it is, I've seen it happen fairly frequently where you can have, not in your practice, I don't recall seeing this in your Practice Act, but you can have situations where in one statute they're defining person, much like how you just said, and then in another statute 3 down, they're using a word that wasn't even a part of that definition. So we'll look to ensure that we're using the most consistent language. So for example, whether that language is corporation or whether it's entity, or like you said, if person is somewhere in here that I'm not recalling and actually encompasses all of it, then, we can, look at that definition and make sure we're capturing it. So yeah, point taken about the definitional aspect.
So unless anybody else had a comment on that, I would just ask then that staff partner with Rebecca to clarify that language for us and make sure that it's encompassing as our intent.
So Glenn, can I ask you a question, or through the chair, can I ask a question? I think that this committee's already answered it, but I just want to make sure, because it raises, you identify an interesting issue, and I get that the DOC and this committee has already decided or agree that the $35,000 penalty in some instances can be imposed upon individuals, depending on the facts of the situation. Is that right? Is that the kind of consensus view of the two committees? Because if so, then the language stays the same. If there's a feeling out there that only businesses should be subject to the $35,000 penalty, then some of the the placement of the section is an issue, and yeah.
So this is Natalia. I just want to clarify that not only can individuals be as subsequent lens business, but they can be RDOs, as a sole proprietor can have an RDO business. So the original intent was to have individuals, so it encompasses not only SLDs, but RDOs as well, who own their own business. And if regulation is really what's meant to intend, from what I understand what talks with Rebecca, to be able to clarify, this is what we could charge for this specific infraction by this specific license type. So this is kind of like the max you could do. And it is not it's not going to be the baseline of what we do every time.
I think the most important thing here is, if I can just offer a solution, go forward. I say we include corporation, and that we realize that the kind of specificity we're talking about is really what we're going to be working on when we do regulations, that we will really dig into what fines and what frequency of infractions, what severity of infractions will garner what level of fine here. But that what right now, really all we're trying to do is to clarify that there is a range, and this range is higher at the end because our intent is to go back and make sure that businesses are able to set up business models that take advantage of a low fine. Does that make sense or work for the committee?
Yeah, works for me.
Shara, question?
Yes, sir.
Where does an entity like a drugstore chain come in, since they dispense contact lenses? Does
they don't dispense? So I'm not going to touch that. I think that's an excellent practical question that we would need to look into.
I just want to know if these regulations cover, you go into JJ's pharmacy and say, hey, you guys have AccuView lenses. This is what I wear. And they sell the person contact lenses. Does that fall under this?
So this is Natalia. I can tell you that a lot of different pharmacies, specifically right off the top of my head, CVS Pharmacy is registered as a registered dispensing optician because they dispense lenses. So
okay.
Yeah. So a pharmacy that dispenses contact lenses should have an RDO license. If they're just handing out contacts, they may not need a contact lens dispenser to be able to dispense those glasses, but they just need the RDO business type to do that.
Okay, well, and then that goes back to Glenn's point with having an entity instead of a person.
Or corporation, because that is a
Corporation, yeah. Corporation is
So
kind of a
we'll keep
person.
changing the language within, or we'll just change within the language within 2541B1, any person or corporation who violates any of these provisions. And then clearly you get everybody we're thinking about, and this is the whole range. And within our regs, you'll see where we break down infractions and frequency of infractions and how those garner fines.
Okay, that answers my question. Thank you.
Okay, then my last comments are on page 27. I actually have a couple comments. So related to the top paragraph, section 2559.15, I still remain to have concerns about this requirement. I believe that currently in our industry, unregistered, trained employees are dispensing. And from a flip side question, as far as access to care, if we were to continue on with this particular wording, I'm thinking about the secondary repercussions when we think about the number of SLDs, CLDs out there. And one of the conversations that we've been having more recently on the DOC as well has been encouraging registration for young people that are studying in this field. We heard from schools that not all of their graduates are choosing to become SLD or CLD, which is surprising and slightly shocking to me that they're going to go through this formal training and spend all this money and then actually not become a registrant. So I think that there's two different things that work on this. So one of them is if we change this, it could force the issue of people becoming registered, but at the same time, unintended consequence could be a lack of access to picking up glasses or contacts in the near future. Foundationally, I'm still not convinced that we have to make a change from 5 to 3. I'm also not convinced that it has to be an absolute where there can't be any circumstance where there's not somebody that's registered. So those are just my general comments about that one. I know that I might be alone on those beliefs. And then on the same page, my secondary comments are, again, going back to the same thing, which is my personal belief that it's better to protect consumers if we have more registrants in the field without, in my particular belief, changing this statute from has maintained their American Board of Optometry or National Contact Lens Examiner registration or practiced within another state within the last 5, changing it to 3. I also don't agree with that. I don't think there's any particular reason that I've been given that we have to change that statute. So those are my 2 comments about page 27.
Have I lost a connection? I don't hear anyone.
No, I think we're we're all just in deep in the language on page 27 here. Okay, so you're worried about me about turning away people who would practice because they, and you're, so actually I'm picking up on your second one here rather than the first, but we could, let's see. So this change would make it that somebody has to have done this thing in the last 3 years rather than the last 5, and your concern is that that turns people away. The applicant for renewal is not engaged in this time. You know, I think, well, okay, go ahead.
I think that that's a really kind of a more complicated question. I think that part of it is, right, that we, for opticians, only have title protection. And so if you can work without having to pay the $400 registration fee and then $200 renewal fee every 2 years, then I think folks would want to save that money. I think that we have to be very careful about kind of what we think brings folks into or out of the profession. And really, you know, we're starting the work of doing that occupational analysis for unlicensed assistants. But until we've got that back, I really, I think what we're hearing, until we've got that back, I want to be careful that we're not making an assumption that better quality control will prohibit people from coming into the profession. I think what we've got to take into account is the professional members of the Dispensing Optician Committee who said that if you're going to be able to adequately supervise and check the work of those you're supervising, that 5 is too many, that 3 gives you an opportunity to really make sure that those untrained people on the floor are doing the work in the manner that you as a trained professional would want the work to be done. I think that's where we are right now. And I think that that's why we're looking at this change in number, because there really was a feeling among a professional members of the Dispensing Optician Committee that quality control wasn't possible with that many untrained folks on the floor, and that you would need to have more time to spend with each untrained person each salesperson on the floor, in order to ensure that they are applying the principles that you have been educated to bring to the profession.
So I was a part of that discussion on the DOC, and my point of disagreement with them is they spoke anecdotally and they were unable to produce anything data-wise as far as risks to consumers. That was the basis of my disagreement. Is there was nothing that was telling me through any processes that had happened with the board that there was a risk to consumers with our current statute. And again, they were speaking to their experience, but it's their individual experiences. And I want to make sure that if we make a change, it's encompassing for all and makes sense for consumers, as opposed to increasing the difficulty for the registrants.
Hey, that brings up a good point. So I was about to say that, maybe, I was about to say that for the legislature to adopt certain changes, they may want to understand why those changes are called for. So if it's not enforcement staff saying, oh, look, we have X problem. If instead you're saying it's a committee saying, oh, well, here we have X problem, then, that is something that maybe this all this all depends upon the legislature actually instituting these kinds of changes. And that kind of information might be something that they want to understand before they do. The other thing is that, I don't think that, so you kind of hit on that point about what is it that we actually know about why this change would be needed.
So this is Mark. Glenn raises some interesting points. This is a policy question, not a legal one. And it's up to us as initial policymakers to decide whether it should be 3 or 5, and then convince the legislature that it should be 3 if we want to change it from 5 back to 3. So I think we as a committee and the board need to be comfortable with the change, and as Rebecca has pointed out, that we're willing to articulate to the legislature why the change is necessary. Now, anecdotal information is still information. We have experts on our DOC that we can rely upon, but if we feel that that is not enough to convince the board of the board members, then it's not enough, and we need more information, or we need more evidence to support it. I think that's up to the committee and the board as to whether or not we think it's enough. If I can add, can we present to the legislature or even present to the board to get the committee moving along, is to put an option in here, 3 or 5, that either the board can come to a further decision with more input from the public, or to offer it to the legislature with those 2 options.
I agree. Both of those options are kind of a nice forward-looking or moving it forward approach.
I would be okay with that, but the only one ask I would have is if there is no data to support a change as far as enforcement, I want to make sure that at the full board presentation, they know that we don't have anything but the opinion of the professional members of the DOC. Because again, you know, when it gets to the legislature and we're in front of a committee, and if we're being grilled on this, I don't want to, you know, have a board member sitting there saying, "Oh, well, it's just the opinion of our professional members." Okay, so what data and consumer risk are you talking about? And we have no data to support it. It just makes me feel uncomfortable that would be a situation that our board would be put in.
Should we have members of the DOC, not you, Glenn, but some of the opticians come to the board, to the full board meeting also when we discuss this, so that everyone on the board, full board, can hear their opinions as well?
Madam Chair, we do within our audience today have Anna Watts and Bill Casella, who are members of DOC. Anna is a professional member. I don't want to put her on the spot, but if you were looking for additional kind of conversation when here within this committee, then you could, of course, open up public comment to include that.
If that's okay with all the members on the committee, I would like to open up for public comment to hear what they have to say.
All right, this is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment, please click that icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. Currently sharing instructions on the screen for your reference. And I'll pause a moment to allow the public time to access that Q&A panel and submit their requests. All right, this is the moderator. Looks like at this time there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
All right, the Q&A panel is now closed.
So maybe, Shara, we could, for our next board meeting, or have other members of the DOC come and talk to the full board when we have this discussion again.
We can certainly seek that out. Yes.
Okay. Glenn, do you have more comments?
So this
No.
is just there. I apologize. I just wanted to clear up before we move to other comments. So is there agreement among the committee if the number is 3 to 5? I thought I started to hear agreement. You know, I like agreement.
So I think Mark was proposing that we would bring it back to the full board, saying that we're trying to figure out if we need to change it from 5 to 3 and present it more as an option. And then if the board can't decide, then Rebecca was also saying that we could even have it in our proposed changes to the legislature to have 3 or 5.
But wouldn't the legislature want to know why we're proposing 3 or 5? I think as a board, we might want to pick a definite.
I certainly would prefer for the board to have an agreement on whether or not they think there needs to be a change or not. I think that's most appropriate is if the full board feels that there should be a change, then we present it to the legislature that way.
So let's say we change it to 3, and then someone's been out for 4 years or 5 years. So what do they have to do in order to get research? Do they have to go through another certification process? I guess what's the hurdle if we change it to 3?
So this is Natalia. If they were working in another state, as per said in the statute, then they would just have to give me their letter of verification from that state, say, oh yeah, I've been doing this here. It could be from that board or it could be from their employer. I accept either because not every state is licensed. If it's been over the 5 years, they have to retake the ABO exam because I don't know what they've been doing for that 5 years. They don't have to go back to school or anything, nothing like that. They just have to retake the exam, which is similar to our reinstatement for optometry, which they have to retake part 3 in order to be reinstated.
Okay.
It's kind of an assurance of competency when you come back from being canceled that you can still do the job.
Thank you.
And Lillian, one other point I want to just bring up is that we're talking about 2, 3, or 5 numbers in 2 different statutes. So there's a proposal right now to change it from 5 down to 3 as far as optician trainees to SLD. And then the other one was, I think, the reverse change, 5 to 3 years.
And Dr. Kawaguchi, I can speak a little bit about that 5 to 3 years because we changed that specifically because that's what optometry is. If you are in delinquent status for 3 years, you go to canceled, and you have to retake part 3. So the reason we brought that down from 5 to 3 was to match the optometry standard that you're going to have to retake an exam after being delinquent for 3 years.
I appreciate that thought. I don't agree that it's justified just to compare it to optometry, since they are different professions. Because optometrists, we have to carry malpractice and liability, and I don't believe that SLDs have to. So it kind of reflects the risk difference as far as risk to the consumer.
So I will just say that I think having to retake the ABO exam would be a pretty significant hurdle, I think, for a lot of people. I don't know. But at the same time, we do want to maintain competency. It's a difficult question, but I think for a lot of people, having to retake the ABO exam, if they've been out for 3 years, would be a deterrent, especially since they can work without being certified.
So if I can make a closing comment about the post that we're going through right now. So the regulations for opticians and RDOs has needed to be updated for quite a while. I think we all agree on that. But what I'm not supportive of is making changes without reason when it comes to consumer protection and or access. So that's kind of the foundation of where I'm coming from with my feedback around the different changes that are proposed. So I just wanted to kind of summarize on that.
So it doesn't seem anyone else has. Oh, sorry, Dave. Go ahead.
I just found a dead horse I want to beat. If somebody is a licensed spectacle dispenser and that person is a regional manager for some large optical chain, and they don't practice opticianry, they don't fit and adjust spectacle lenses, but they go around and oversee 20 locations. Does that person, even if they maintain their ABO certification, does that person still have to fall under this where they're not substantially fitting and adjusting eyewear? Does that impact them, or are they still dealing with they're still dealing within the practice of opticianry? They're just doing it from a management standpoint.
Right, but they're still maintaining their registration, so it wouldn't apply to them, right? Because if they maintain their registration for 10 years, then we as a board wouldn't know.
Well, if an applicant for this is saying that if an applicant for renewal has not engaged in the full-time or substantial part-time practice of fitting and adjusting spectacle lenses, but has maintained their ABO or NCLE registration, the board may require the applicant to take and pass the examination referred to in this section as a condition of registration. So what I'm reading, and I could be reading it wrong, is that if you're not actively fitting and adjusting glasses, then you can end up having to take another test after 3 to 5 years, even if you're still involved in the profession, but in a different status.
So this is Natalia. That could be the case if they decided they weren't going to keep up their license. If they were like, okay, I'm going to be a manager for the next 5 years, then why do I need to do this? But if they've decided they wanted to keep up their ABO certification, we accept that because you take CEs to keep that up. So it's possible, but there are several options for them to be able to not have to take the exam. You can either keep up your certification, show proof that you've been working as a fitter and adjuster, and if not, then yeah, you would need to retake the exam.
Then I'm reading something incorrectly here. 2559.2, right in the middle of that section where it's highlighted, has maintained their American Board of Opticianry or National Contact Lens Examiners registration or practice within another state. It's at the beginning of that sentence, it says, if an applicant for renewal has not engaged in the full-time or substantial part-time practice, even though they still maintain their ABO certification, we can make them take and pass a test. Isn't that what that says?
That was not the intention. That was the confusion. I highly recommend changing that language because that was not the intention.
Am I reading it incorrectly? That's what I want to know.
No, I think I'm reading it that way too. If somebody's trying to renew, they haven't been practicing, at least not full-time or substantial part-time practice.
Whatever that means.
Yeah, fair enough, right? That too. But has maintained this ABO or NCLE registration or been practicing in another state, then within this time period, then the board can say, okay, well, pass this test, and then we can renew you or give you registration. I agree. That's how I read it as well.
So that seems to be penalizing somebody because they're not putting glasses on people's faces on a regular basis.
Yeah, well, isn't the opposite? Okay, so it looks like this is so that if somebody's coming from out of state, let's see. If someone's coming from out of state, they could have been doing plenty of, they could be practicing full time. It's just that they're coming from out of state, so it's a kind of reciprocity issue in that case. No, you're right. Let's see here. So, but has done this or that. No, you're right. The first part of that sentence is sort of already presupposing that they're not practicing, but they just happen to be coming from out of state, or at least it's not clear if that means they're practicing out of state.
I definitely would like to workshop this with you, Rebecca, at later point and figure out how exactly we want to phrase this, because that's not what I want at all for this
like
section.
That. Interesting. Yeah, let's make sure we're clear on what our goal is, and then totally. As long as we're clear on what we're getting at. Yeah.
I apologize, but I have to go backward because Dave's comment actually spurred a thought in my head about something that I hadn't thought of before related to 2559.15. So currently in our industry, we have consumers receiving glasses through the mail. And the way that we are proposing the statute, it penalizes physical businesses, but it does not do anything to ensure consumer protection from eyewear received via mail order or online. Does it?
So this specifically is specific to spectacle lens dispensers, which are in person in store. So I think what you think of as would probably apply to registered dispensing optician businesses that do things online, and not necessarily to the spectacle lens dispenser itself.
So currently, with our current laws, it's okay for an RDO that is an online business to mail order dispense glasses to a consumer, and they're not subject to this current statute that we have. Is that correct?
I just want to make sure I'm looking at the right statute. What section is this again?
2559.15 is what I'm referring to, but I'm not sure if there's anything in the RDO statutes that protect consumers from just being sent glasses in the mail. And the reason I thought that up is Dave's comment, and then I was thinking about at my own office, I constantly have consumers coming in that they're my patients, but they got their glasses elsewhere, and now they're coming in to ask my staff, who are trained, to adjust their glasses because they were not adjusted at all. And in some cases, we're having to analyze and realize that the measurements were not actually done correctly. And so there might be a loophole of risk to consumers related to dispenses that are currently not regulated.
This is Mark. Glenn raises an interesting question. I think the committee has to decide. This may be one of the whether the perfect is the impediment to the good. It's raising an additional regulatory area. This committee can decide whether or not to tackle that additional area or have the DOC weigh in on it. Seems like this is an area that's important, but nobody has discussed it. Or we can brainstorm it and see if it's already covered or needs to be covered with additional language someplace. I'm sorry, I'm not giving any solutions. It's just kind of talking stream of consciousness.
So my suggested solution related to not only questions and comments that I've had in other sections, but also related to this new one, is my personal opinion is we need to continue our work as a Ledge Reg committee. These statutes have been in existence the way they are for quite a while, and my preference is to get better to what way did you word it, Mark? Good versus
The phrase is, the perfect is the enemy of the good.
okay. Well, I want us to get a little closer to perfect as opposed to adequate if we're going to make changes, because it's not easy for us to get through a legislative process to make the changes that we need to make. So let's make sure that they're at minimum good. And if there is something as big as this opportunity, I want to make sure that we work through it before we present something to the full board, so that the way that I would look at it is let's bring it to the full board when we believe that we all are in agreement that we can move it forward and take it to legislature. And I personally don't feel like we're quite there yet.
So would it be a good idea for Ledge Reg to meet with the DOC? We could have would that be possible, or would we have to?
Depending on numbers, then you start getting into almost full board territory in terms of noticing the meeting or that kind of thing.
I think that the other two DOC members are not board members, so it would basically just be Ledge Reg meeting with two non-board members. Because Dr. Kawaguchi is the only board member of the DOC.
I think it would need to be a joint meeting, because essentially we would have 3 members of the DOC, the 3 members of the DOC. So we can look into how we might structure some sort of joint meeting and come back to you, Madam Chair, for options with that.
That sounds good.
Lillian, my suggestion on that would be for us to just have a Ledge Reg committee meeting and invite members of the DOC.
Okay.
That would be my suggestion.
Sure.
I agree with that, by the way. That's the exact approach I would take, which is why I think today, if there's any room for that, or if there's any contribution from DOC members today, that might be helpful.
Yeah, I think either one of them was commenting earlier.
Yeah, I think it's just a little difficult when the discussion goes on, right? And it's not possible for DOC members to interact as staff is able to interact with the board, or council is able to interact with the board. We could bring this back, I suppose, and have it be a presentation from one of the board members. I'm not sure that will get to what you want either, though. I think we're looking for an opportunity for the DOC members to communicate with the LRC committee members in the same way that we're able to communicate now, as opposed to a stream of consciousness discussion, opening, public comment, and then a need for an individual member from DOC to address all of the comments that have made before. Mm-hmm. So I think maybe we should just take a look into how we would do that in order to allow both the vice chair, who is a public member, and then also our one professional member who is an optician, to be able to give comments. I think that there are some different skill sets that are brought to that. I think that, Mr. Casella has really dug into the language and would like to be able to more pointedly have discussion here. But I don't think that this format works as well as it could.
Okay, so can we go ahead and see? Let's look at the calendar sometime soon and see if we can get another meeting. The Fed meets and we invite the DOC to present to us so we can have a better discussion. And then in the meantime, can Natalia and Rebecca work on those different areas that we were talking about to see if we can clean up some of the language? So I was at 2559.2, where Dave mentioned that all the different sections that we've talked about. Sorry.
Can do.
Madam Chair, if I can make a suggestion, since it sounds like this legislative package has gone back and forth between the Ledge Reg and DOC and both committees have discussed it a number of times, rather than an omnibus presentation by the DOC. Are there particular sections, and they're obvious from the comments of today and from the comments on the document, that we can say we're going to focus on? Because I have not been a member of this committee, but my fear is that if we start from square one, it's going to be a humongous long meeting.
Right. So I don't know if Shar, if you want to tell DOC or if Glenn wants to talk to them. I think what the big issues are, the 3 or 5 years. I think the penalty has been taken care of if we can include person and or corporation. Is that correct? In regards to penalties?
So possibility could be that we ask the DOC to review where we're at right now with 2559.15 and 2559.2 after staff has a chance to incorporate our comments and have that at their next committee meeting. I think it's just those 2 main ones.
Right. And then just discussion with DOC why in regards to changing 5 to 3 years.
Yeah, and then they could come to a conclusion on what their recommendation is back to the Ledge committee.
Okay.
If they still feel the same way, or that's another way to work it based on Mark's point.
Do we think they need to meet again? Can we just have a joint meeting?
Well, Char, I guess they were saying that it's better to have them be invited presenters.
So I'm not sure. I think we need to work through kind of what the best layout for this would be. I want to make sure that we're accommodating the desire for the DOC, other DOC members to participate, and that we are being careful of quorum for both of these, for both the dispensing optician committee and for the full board. And so let me just work with council and figure out what our best option is for that, so that all parties are able to communicate and have a dialogue and contribute equally. And then we'll set that if it's whether that's the next DOC meeting or the next LRC meeting or a joint meeting, we'll figure that out in order to accommodate participation by all parties.
This is Mark. I don't see quorum as a problem. If there's a quorum, we just notice it as a full board meeting or a full, DOC meeting. It's just we can do it. We just have to notice it properly.
So I want to make sure that we do. I don't want to make that assertion now here on the phone. I want us to just make sure that we go back and take a look at this, and that because DOC is a statutorily mandated committee, it's not a policy committee ad hoc like our others. I just want to make sure that we're approaching this appropriately. Of course, we'll notice within the time frame, but just want to make sure that we're doing this in the best way possible, so there isn't any appearance of decision making happening with more persons than should be a part of the discussion.
All right, that sounds good. Thank you, Shara. So is there in just being aware of time, are there any other comments? Nope. Okay, well then, in that case, Shara, if you and council could figure out what works best, then let's go on to item number 5, which is future agenda items. Does anyone have any discussions for future agenda items? Nope. Then we'll go ahead and go on to item number 6. Do I need public comment before we go into adjournment? No?
Catch that unmute button there. No, you just called for public, or you called for future agenda items, I think. Nope, you're good.
Okay, well, let's go ahead and go on to agenda item number 6, adjournment. Thank you, everybody, and we'll see you guys again in about 20 minutes at the full board meeting.
Thank you all.
Thanks, guys.
Thanks, bye.